Hello, my true crime lovelies. How are you? I hope you are well. All right, this should be short and sweet. Fingers crossed. I wanted to respond. There's a bunch of comments on the last Sarah video and her ridiculous letter that she sent to Kraynick without addressing him, called herself an appellant, even though she's a defendant in the lower court. The handwriting is the first one. I totally missed it, but now you and I we're gonna become handwriting analysis analysts together. Let me pull. Actually, let me run the intro first, like the members, and then we'll take a look at her actual handwriting from her last filing in family court and the handwriting on the envelope that was submitted with this last filing, her inquiry, as she called it. I'll see you on the other side. All right, so here we have on the top is what she submitted from her last filing in family court, which is why she's the respondent there. And then at the bottom, the envelope that she sent with her inquiry that she submitted to the 12th District Circuit Court. A couple things right off the bat. The S here is definitely not this S here. This, you can see there's several touch points of the pin, like right there, maybe right there. And this one that's hers is top heavy on the swoop, right? And this one is bottom heavy on the swoop. The R, this seems to be just one swoop, where Sarah's seems to be a 3-point, like she started up here, went down here, went that way. This one just seems to be like, woof, swoop. And then there's a bunch of little like curl ups at the end of these. Whoop. It's obviously like a wetter pin, but this B looks pregnant. Takes one to know one, where this one does not. And then you see how her BOO N are all about the same height, where this one is clearly the capital pregnant B is much higher than these. And we see those little flare ups at the end again. But I think the most obvious one is the 7. So look how she wrote her 7 here, right? Compared to this 7 that has the line through it. So yeah, you guys were right. I missed it. Definitely not her handwriting. But then why did they send it in there? I guess I'm confused because the information was on the letter. It's very strange. Or maybe they were running behind the gun. They were going to send it in here and then they got to the post office days later than they wanted to. It still would have missed the deadline because it's on the docket as the 8th, even though they mailed it on June 30th. It didn't get there till July 8th because it was coming from Connecticut. I don't know what these people are doing. And then someone else pointed out that the citations were not only California, but they had gone to the US Supreme Court. So I want to look at those. It's still what I said is true about, even if it's at the Supreme Court, the fact that it's in California, it has less precedence than if it was Supreme Court in Florida. I did double check that. But this doesn't really apply to her because the California law is a little bit, well, I don't know if it is today, but in 1963, it definitely was. So basically, at least in 1963, there was a review process before a defendant could be assigned an appellate attorney. So facts of the case, petitioners were jointly tried and convicted of 13 felonies in a California court. They were both represented by a single public defender who sought a continuance at the commencement of the trial. That request for continuance was denied. Petitioners dismissed the public defender and then requested a continuance since they were no longer represented. This request was also denied, and the petitioners were convicted of 13 felonies, which is interesting because the court would have had to accepted their withdrawal, right? So at issue was whether assistance of counsel during the first appeal is a fundamental right. And the court held that yes, indigent petitioners are entitled to appointed counsel at the appellate level. And we kind of get the explanation in the dissent, right? Justice Tom Clark believes that California's practice of requiring the District Court of Appeal to first review appeals, appointing counsel only in cases where the court determined there might be a meritorious appeal, satisfies the requirement that the state affords adequate and effective appellate review to all indigent defendants. So he's descending from what the majority is and saying that is sufficient, but the majority is saying no, it's not, because then indigent defendants are not equally yoked, basically, because someone with money can pay for an appellate attorney and have an appeal filed irrespective of if there's like this group review, right? So majority reasons that denying an indigent counsel an appeal results in discrimination against the indigent. The Constitution does not tolerate discrimination. California's present system is discriminatory because a person who can afford counsel is able to submit briefs and partake in oral argument before the court makes a decision on the merits. One who cannot afford an attorney has his appeal judged on the merits based upon the bare record from the lower court, hoping that pages will reveal blatant injustices. So that doesn't really apply to Sarah because there's no board that's looking at it first. She was assigned an appellate attorney, and so I'm not sure what she's going after there. All right, and the second one, Anders v. California, piggybacks off of the first one, off of the Douglas et al. California, except in this instance, the appellate lawyer was assigned, did not think there was any merit to the appeal, advised the petitioner, advised the court, and basically the petitioner wanted to file something and asked for another attorney. That was denied. He filed a brief pro se, and then there came out a ruling of like this counsel being an advocate for the client. So even if they find there's no merit to list it out, basically, I'll let you guys read it. It really doesn't apply to Sarah because again, this person was assigned one lawyer and then asked for another one and was denied. So in both of the citations that she provided, they got one lawyer. So she's got her one lawyer. If it doesn't work out, it doesn't say anything in there about getting you another one. Yeah, so anyway, thank you guys for all your comments in the video. I appreciate you, and I just wanted to do a little recap. I don't want to call it corrections, but just a deeper dive, I guess. Let me know what you guys think, especially about the handwriting, for those of you guys who didn't notice it like I didn't notice it, or if you did and have your suspicions about why they put that letter in there in the first place, drop it in the comments because I am baffled. I don't know why they just didn't send it in the outer envelope or mail it in that envelope and put postage on there. I'm perplexed. Maybe they would have ran out of time. Anyway, I could rack my brain all day. I'll talk to you guys later. Toodles.